The Americans with Disabilities Act, or otherwise known as the ADA, is a federal law that seeks to prevent or prohibit disability discrimination in various aspects of life, whether that be employment, government services, or other areas. Title III of the ADA specifically looks at prohibiting discrimination based on disability in places of public accommodation. That is a legally defined term. Some examples include restaurants, gyms, retail establishments, movie theaters, and other similar types of facilities. So traditionally, when we looked at litigation or questions arising about places of public accommodation in Title III of the ADA, it was looking more at a place of public accommodation's physical structure. So for example, if I own a retail business, do I have the appropriate amount of handicap parking spots? Do I have an accessible front door for patrons who may utilize a wheelchair? Or do the door frames in my business, are they wide enough, again, for someone who uses a wheelchair? Those are just a few examples. However, since about 2003, so for about 20 years now, the Department of Justice has said that websites of places of public accommodation must also be accessible for disabled patrons. Essentially, website accessibility is ensuring that all patrons are able to access the website of a place of public accommodation. And so I think the best way to describe this is through an example. So for example, if you have an individual who wants to go online and shop for a certain item, but they are visually impaired, they'll need to use potentially a screen reader to be able to peruse that website and purchase that item.
Winter fashion finds heading level 2. Link all fashion. Link women. Blank. Link men. Link kids. Blank.
If your website as that retail store is not compatible with the screen reader, the individual will not be able to access potentially all of the website or even portions thereof. And in that way, it's no longer accessible to all patrons, which it's required to be under the ADA. Unfortunately, yes. So in 2022 alone, there were over 3,000 lawsuits filed based on website accessibility issues. So most of these cases are filed under Title III of the ADA, but there are also corresponding state anti-discrimination laws that can serve as the basis for these types of lawsuits. This is a trend that we've seen in an uptick since about 2017, with 2022 having the highest number of cases filed. This is also unfortunately not a distant threat for Oklahoma businesses. We've had local businesses who have received demand letters based on website accessibility issues, or have even been the subject of litigation because of that. The real question too is, what are courts doing about these cases? How are they responding? And again, unfortunately, the answers are pretty unclear. Some circuits and courts have really not provided any guidance on whether Title III of the ADA applies to all websites of public or places of public accommodation. Other circuits have taken a different approach. We also have questions about who is the proper plaintiff or person to bring these types of lawsuits. And that question is something that's actually going to be in front of the Supreme Court this next term. Right now, litigation is definitely a concern for places of public accommodation with respect to their websites. If you become the subject of a Title III ADA discrimination case, what's obtainable by the plaintiff bringing that lawsuit are attorney's fees. And so this number can vary based on the size of the business that's involved. You have attorney's fees for your own attorney to defend the litigation. And so these can total to thousands and thousands of dollars on top of working to then remediate your website as well. So the best thing that that a business can do, and what will make good business sense for many businesses, is to work to remediate their websites. And so what that means is they're looking to ensure that their websites comply with the Web Content Accessibility Guidelines. So you'll see that's abbreviated to WCAG. Those guidelines are typically the standard that are followed within the website accessibility forum, if you will. Given we do not have clear legal guidelines for these types of cases or these types of issues, the WCAG guidelines provide what most businesses are looking at. And this is where counsel becomes really important. So not only can speaking with legal counsel help you understand, who to look for in the reputable remediation services or companies to help fix your website, but you will work hand in hand with counsel to ensure that in making those changes, you are mitigating further legal risk, which is ultimately one of the main goals of remediation, along with ensuring that your website is accessible for all patrons.